Hi everyone, my name is Justin Sterling. I am an attorney and the founder of the Sterling Firm. We are discussing the advantages and disadvantages of utilizing the different types of corporations as the business form for the production company and as a financing vehicle. The corporation. Corporate financing requires the filmmaker to sell equity interests in either the film or production company in exchange for the funding. The corporation is an ideal business form to attract numerous investors or to raise money from the general public. The corporation business form may be ideal for the filmmaker in structuring a production company because it lends to business growth. The corporation may also be ideal as an investment vehicle for a specific film project because it allows the risk to be spread amongst many investors through equity ownerships in which the investor will recoup their investment only if the film shows a return. The most ideal situation for the filmmaker is to raise all the film's costs from an equity investor in exchange for a much less percentage of the film's income. For example, a filmmaker can raise 100% of the budget from the sale of equity in exchange for 25% of the film's income. The filmmaker will have a share in the profits and will not incur a risk of any monetary loss. Moreover, generally speaking, the corporation business form also provides liability protection to the owners in that only the amount of their investment is at risk and not their personal assets. A separate legal entity. A corporation is a business entity organized under state law to act as a separate legal entity apart from its owners, who are called shareholders. A corporation can operate as any other legal individual. That is, the corporation can own and buy property, borrow and lend money, sue and be sued, and even be liable for criminal acts. Because the corporation is a separate legal entity, the corporation must file its own annual tax return and pay taxes on its profits. In general, this is separate and apart from the personal taxes that the individual shareholders must pay. The formalities. 1. Articles of incorporation. The articles of incorporation must be filed with the Secretary of State and a certificate of incorporation must be received. Generally, there is a filing fee for the articles of incorporation in addition to a franchise tax fee. 2. Initial shareholder meeting. An initial meeting of shareholders must be held and the directors must be named during the meeting. Minutes of the initial meeting must be maintained. 3. Board of Directors meeting. The Board of Directors must have a meeting in which they name officers, set up a business bank account, issue shares, and approve the bylaws. Again, these corporate decisions must be reflected in the minutes of the meeting. Share certificates must be physically issued to shareholders, and the issuance must be recorded in the official corporate log. In addition, if the Board of Directors decide that the corporation should be treated as an S corporation, the decision must be noted in the board meeting minutes along with directions to be followed by the corporate officers to file the necessary documents with the Internal Revenue Service. The annual Board of Directors meeting should be held immediately after the shareholders meeting. 4. Bylaws. The bylaws for the corporation must be drafted and approved by the Board of Directors. To note, the bylaws are not an agreement between shareholders, whereas an operating agreement for a limited liability company can be an agreement among the business and the members and may also be an agreement between the members and the other members of the LLC. The bylaws are the controlling provisions on how the corporation is to be governed, not an agreement amongst the shareholders. The bylaws must state the date, time, and details for the annual shareholders meeting. 5. Regular meetings. The Board of Directors schedules periodic meetings to evaluate the officers. In turn, the shareholders generally have an annual meeting to evaluate the directors. For instance, California requires that there be an election of at least a portion of the Board of Directors each year. And 6. Perpetuity. The existence of a corporation is perpetual. That is, it lasts forever until the shareholder vote to terminate the corporation or finances cannot support its existence anymore. Corporate control. The corporation is managed by the Board of Directors, operated by its officers, and owned by the shareholders. The stock in the corporation is conveyed by issuing shares, which are units of ownership or equity in the business. The person who purchases the shares is the shareholder and has a claim to the business assets and earnings. The shareholders have only the ability to vote on significant business events such as mergers and the election of directors. There are many devices available to control the way shareholders will vote, such as non-voting shares, voting trusts, shareholder agreements, and the requirement of a supermajority vote on certain issues. Furthermore, shareholders may even grant a proxy authorizing another shareholder to vote their stock share. Written shareholder agreements can make the shareholders bound to elect the same person as director and officer of the corporation. The same individual can be both a shareholder and a director or officer of the corporation. Directors, officers, and managers of the corporation have the authority to obligate the corporation by entering into contracts, loans, and making other business decisions. Directors are usually professionals experienced in managing the business and can hire the necessary employees. Directors appoint the corporate officers who manage and run the day-to-day operations, such as the president and chief executive officer. Most often, there are about 3 directors elected to make decisions. However, most states do not impose any limitations, and there may even be allowed only 1 director. The board of directors are bound to manage the corporation according to the bylaws. The bylaws dictate how the corporation will be governed. Moreover, directors and officers are bound by fiduciary duties to exercise loyalty to the corporation. In doing so, directors and officers cannot use corporate assets or usurp opportunities in line with the corporation's business purpose for their own personal gain. Limited liability protection for shareholders. The shareholders are protected by the corporate shield. That is, the shareholders only risk up to their investment in the business. Shareholder liability is limited to the amount they invested and their share in the profits. Shareholders will not incur personal liability as long as the corporate shield exists. Therefore, generally, shareholders' personal assets will not be at risk if the corporation cannot pay its debts or if the corporation incurs liability. Piercing the corporate veil. However, there are certain factors that may cause the corporate shield to be pierced. Some factors include commingling of personal funds with the corporation funds, paying personal expenses with corporation funds, failure to follow corporate formalities such as conducting meetings and maintaining minutes, failure to issue or subscribe stock ownership in the corporation, only 1 shareholder of the corporation or all stock owned by close family members, or the corporation was inadequately funded. These are only a few factors that show that the owners were merely using the corporation as an alter ego and may lead a court to pierce the corporate veil, allowing creditors to recover from shareholders' personal assets. The corporation's shareholders generally are not personally liable for the business's debts. That is, if the business cannot pay its debts, the creditors usually cannot sue the shareholders. Generally, the contract and tort creditors must first look to recover from the corporation business entity. However, if the business never had enough capital to conduct business to begin with, then a court will find the shareholders to be personally liable. It is important that the filmmaker make sure that the business has enough funds to pay for insurance, to cover all risks, and to pay any debts. Otherwise, the filmmaker will lose the corporate veil protection and be at risk personally. Corporation tax treatment. Corporate tax rates are higher than individual rates. Therefore, the corporation will owe more tax on business earnings than if the filmmaker conducted business as a sole proprietorship and reported the same amount of earnings on a Schedule C. Double taxation. A higher rate of tax is not the only disadvantage of using a corporation. There is also double taxation. First, the corporation pays taxes on income it earns in the year it is earned. Then, if and when the income is distributed to its shareholders as dividends, the shareholders also pay tax on the income, resulting in the income being taxed 2 times. Moreover, business profits are only paid to the shareholders upon the board of directors vote to distribute dividends and in proportion to the shareholders' respective ownership interests. The flexibility of revenue sharing among management and investors is restricted as compared to a limited partnership or a limited liability company. C corporations versus S corporations. For tax purposes, there are 2 different kinds of corporations: C corporations and S corporations. C corps are standard corporations subject to double taxation in the case when dividends are distributed. C corps are allowed to have an unlimited number of shareholders, whereas an S corp is usually a small business entity with only a few shareholders. S corps. The name S corporation comes from subchapter S of Internal Revenue Code. The term S corporation means a small business corporation, which has made an election under Internal Revenue Code section 1362A to be taxed as an S corporation. A corporation that qualifies under subchapter S of the Internal Revenue Code is not subject to federal income tax at the corporate level. Rather, an S corp qualifies to be a pass-through entity, just as a partnership. Even though it is a separate entity, for tax purposes, the entity may be considered a pass-through. The shareholders of an S corp will be taxed on their portion of the income for the corporation, regardless of whether or not the income is distributed from the corporation to the shareholders. However, there are some rigid requirements to qualify as an S corp. A small business corporation is an eligible domestic corporation that qualifies to be an S corp if 1. The corporation does not have more than 100 shareholders. 2. The corporation does not have as a shareholder a person who is not an individual. Exceptions are made for various tax-exempt organizations, estates, and trusts. 3. The corporation does not have a non-resident alien as a shareholder. And 4. The corporation does not have more than 1 class of stock. No more than 100 shareholders. An S corp can only have a limited number of shareholders, under 100. A husband and a wife are treated as 1 shareholder. An S corp may not be a foreign corporation, that is, an entity that has been formed outside the state. Moreover, shareholders must be citizens or resident aliens with a green card. Loans from foreign countries that have equity characteristics are problematic. Only resident individuals. The IRS prohibits corporations from owning shares of an S corp. If the production company is another corporation, that separate investment vehicle used to raise funds for an individual film project cannot be an S corp. While S corps can be shareholders in C corporations, they cannot have an ownership position in another S corp. In addition, partnerships, as well as non-resident aliens, cannot own stock in an S corp. This is because S corp stock must be owned by individuals. An intricate exception to this restriction is when S corp stock is owned by a single member LLC. No more than 1 class of stock. An S corp may not have more than 1 class of stock, meaning the S corp may not treat shareholders differently. However, differences in voting rights are disregarded. Therefore, an S corp can have voting and non-voting common stock, a class of stock that may vote only on certain issues, irrevocable proxy agreements, or shares that may or may not have rights to elect a board of directors. Okay, C corps compared. In contrast, standard C corp stock ownership is not restricted to only individuals. Therefore, another corporation, whether an S corp or C corp, may be a shareholder. There are no minimum or maximum number of shareholders in a C corp. An S corp may choose to be a 100% stockholder in one or more C corporations. Therefore, S corps can have fully owned C corporation subsidiaries. The requirements for an S corp make it difficult to raise funds for a film project, particularly because investors many times will come from out of state. However, if their earnings are not to be reinvested and the business is expected to make a relatively quick profit, then an S corp may be an appropriate business form because expansion is not a consideration and double taxation is avoided. It is important to note, an S corp can lose its qualification to be a pass-through entity if any of the requirements are not satisfied. Therefore, if growth is a consideration, a C corp is better suited because profits will be reinvested and not distributed, and an unlimited amount of shareholders is permitted. Agreements before incorporating. A subscription. Before the corporation is actually formed by filing the articles of incorporation, the filmmaker may sell shares in the corporation to be formed. A pre-incorporation subscription is an offer to purchase capital stock in a corporation to be formed, which under many state statutes is irrevocable for a specified time period. Subscription agreements usually involve large amounts of money. This type of offer and sale must be carefully drafted to be compliant with security laws. Any kind of investment is subject to security laws. Securities must be registered with the state and federal governments unless the security qualifies for an exemption from registration. The subscription agreement must have a full disclosure of all the material facts. This serves as part of the disclosure document, usually accompanied with a private placement memorandum, as required by the anti-fraud provision of security laws. The facts that must be disclosed include, but are not limited to, total amount of money to be raised, ownership shares available, shares retained by the incorporator filmmaker, the consideration provided by the filmmaker, such as services, script, intellectual property rights, etc., the transferability of shares, payments to officers, deferred compensation of participants, pre-sale arrangements, loans, credit cards, contracts, and any other financial dealings. Shareholder agreements. Shareholder agreements are an agreement amongst the shareholders. Shareholder agreements can be entered into amongst the owners of the corporation before actually incorporating so that the agreed upon terms of the business are enforceable. As a practical matter, shareholder agreements should in fact be entered into before the articles of incorporation and bylaws are drafted. Pre-incorporation contracts. Any contracts that have been entered into by the principal actors on behalf of the corporation that has yet to be formed will obligate them personally. However, if the contract expressly states that the corporation will be the party solely performing the contract and that the principal is released from any liability, then the principal actors will not be obligated. This type of provision is difficult to have agreed to in a contract. Still, the corporation, once it is created, will become liable when it adopts or ratifies the contract. The principals on behalf of the corporation are not relieved of personal liability unless a formal novation is entered into, which replaces the original party with the corporation as a new party to the agreement. Raising capital and offering shares of the corporation. The initial incorporation process, consisting of the founding shareholders, provides an opportunity to attract startup capital in order to potentially fund 1, the cost of acquiring rights, 2, developing a script, 3, packaging, which is a combination of several creative elements such as the script, actors, and director used to attract financiers or distributors, 4, production, and 5, if necessary, a further securities offering in order to raise additional funds. The filmmaker may transfer his or her rights to a screenplay to the corporation in exchange for ownership shares. The other founding shareholders may contribute property, past services, or cash in exchange for ownership shares. It is presumed during the formation stage of the corporation that the founding shareholders are fully informed and are in a position to protect themselves from being misled. They are also in a position to elect themselves to the board of directors during the first shareholders meeting. In doing so, the founding shareholders are taking an active role in the corporation and are not considered to be passive investors for the purpose of security law compliance. The secondary offering to outside shareholders requires full disclosure to each prospective investor in order to comply with state and federal security laws. The board of directors will need to vote on whether to sell additional shares of the corporation in order to raise additional funds. An alternative method to raise funds for an individual project is to create a separate entity in the form of a limited partnership or a manager-managed limited liability company, in which the corporation could serve as the general partner or the manager. If the corporation is a C Corp, the sale of shares can take on various forms such as common stock, preferred stock, and/or convertible stock. Common stock entitles the holder to vote on corporate matters and to receive dividends after preferred shareholders. Preferred stock is a class of stock giving its holder a preferential claim to dividends, but usually carries no voting rights. Convertible stock is usually a bond or a preferred stock that may be exchanged by the owner for common stock for a fixed price on a specified date. Also, another way a corporation can raise capital is through debt financing, such as in the form of bonds, debentures, and notes. The sale of additional shares in the corporation is considered an offering, which can be either a public or private offering. The legal fees for a thorough private offering range from $10,000 to $50,000. The legal fees for a public offering are even much more substantial. Legal fees for an offering may include any combination of the following: an hourly or fixed fee, an advanced retainer, deferred compensation, and/or a contingency fee depending on the success of the offering. Additional costs for an offering may also include printing costs, accounting fees, financial statements, financial projections, broker and dealer fees and expenses, issuer marketing costs, and state and federal filing fees for public offerings. Practical considerations for filmmakers: growth and control. The corporation is a vehicle for attracting investment. The corporation may be a suitable business form for the production company because it allows for ongoing business growth. This is particularly true if the filmmaker wants to make a career out of producing film projects. However, the corporation is owned by shareholders who will vote on important business decisions and elect the corporation's board of directors, thereby impacting the filmmaker's creative control. Still, the C Corp may serve the interests of investors in that the filmmaker can issue multiple classes of stock, and shareholder agreements can allow the filmmaker to maintain creative control over the project. The C Corp does not offer the pass-through tax benefit of a partnership or LLC. However, this is not too significant, particularly if the investors are more focused on long-term growth. Moreover, despite the double taxation effect of the corporation, there are many tax benefits that are available to a corporation that are not permitted to individuals. For instance, corporations can deduct many types of expenses that individuals cannot unless incorporated. Furthermore, many times investors are attracted to the possibility of expanding the business into public markets. However, this is not a very likely option for an independent film production company or an individual film project. Transferability. Most independent film production companies that are formed as corporations are considered to be closely held. That is, there are restrictions on the transfer of shares from one investor owner to a subsequent owner. A closely held corporation is owned by only a few shareholders and the shares are not actively traded. Investors cannot freely transfer their ownership in a closely held corporation, whereas shares in a publicly traded corporation are widely transferable. Investor intentions. Realistically, many filmmakers intend to return the profits to the investors rather than using those funds for business growth. Most investments are for one specific film, and investors are not interested in funding additional projects. Many corporations are formed to engage in any lawful business, whereas it may be the intention of the investors to have the business restricted to just a single film project so that their money will not be used to fund other projects. Ownership versus contract. More commonly, a filmmaker may find that it is simply more appropriate to negotiate screen credit and a profit participation deal with financiers for a share of the producer's net profits or the film's net proceeds, rather than selling equity shares in the corporation that owns the rights to the film. Profit participation is not considered to be an ownership interest and instead is a contractual right to receive money. Still, the contractual agreement must be clear that the financier is taking an active role in the production in order to not trigger issues with security law compliance. Personal guarantees. Lastly, the benefit of the corporate shield protection is not too significant because film lenders will request that loans include a personal guarantee. Therefore, shareholders can still be personally liable for the debt. Clearly, if a lender is going to make a large loan, the lender will want a personal guarantee. Now that we have covered the advantages and disadvantages of the different kinds of corporations that can be utilized as a production company and as an investment vehicle, you can be more aware of the legal issues involved. Stay tuned for more useful information. If you like these videos, please feel free to comment, subscribe, or leave us a thumbs up on YouTube. And please feel free to forward this video to any friends or family members. If you have any questions, or if you would like a consultation with a lawyer, I encourage you to contact the Sterling Firm at 310-498-2750 or send us an email at info@thesterlingfirm.com. And obviously, the best and most generous way to say thank you is to refer a client or to give a positive referral. Please check out our Yelp page and LinkedIn profile to make a positive referral. Thank you for allowing me to be of service, and I hope you enjoyed this video and have a wonderful day.